Okay, let's get started. I'd like to welcome everyone to our session tonight. UX design, IP protected music. Just a couple of quick introductions. My group is affiliated with NYTECH. NYTECH is a group formed in New York City, basically, started in Manhattan. Earrz is here, he's the founder. Is Eric? Okay. We're essentially a nonprofit association, and we have a number of areas of focus: education, community involvement. We have involvement in Washington under advocacy. We work, obviously, workforce development. We put on about 40 events a year. I manage the UX track. There's several other tracks that are very productive. There's an actual formal legal track, CEO roundtable, a number of other important events. We have about a total of 40 events a year. So we would encourage you to explore the opportunity for membership on an individual basis. It's quite inexpensive. And if you work for a corporation and an interactive studio, we're always looking for annual sponsors. In that regard, we currently have a sort of blue chip list of sponsors who come forward for us. NYTECH is about 5 years old, is that right? Yeah. So we have the likes of Google, IBM, a number of other important sponsors as well. And we have a very wide media sharing membership as well. A couple of additional quick things about NYTECH. As it so happens, we're having an event tonight, which is essentially a legal focus. But there's an event in Manhattan at Ramper next week, which is legal essentials for startups, financing strategies. And all of these events that relate to legal aspects of business planning are tremendous, and they're very, very inexpensive. And then, of course, not least is our annual summer party. We have great parties. So that's on July 13th at 121 Fulton. Okay, so tonight's talk, as I said originally, is UX design and IP. I'd like to introduce my colleagues here. First, Beth Ferrill. Beth is a partner at Finnegan in Washington. She's one of the leading IP experts in the country. Beth and I worked together on a number of seminars for the U.S. Patent and Trademark Association, her office. Beth has a BS in computer science and an MS in computer science, both from the Air Force Academy, which I think is kind of cool. She has her JD from North Carolina at Chapel Hill. Why I chose Beth and why she agreed to come to Washington for this talk tonight is Beth is unique in the sense that she has very broad experience not only in helping entrepreneurs secure patents, but also in litigation. So she has both sides of the sort of the intellectual balancing act that's important to understand how these systems actually work. Then there's Chris Carani. Chris is a partner of McAndrews in Chicago. Chris is another world-class expert in IP. You may have seen Chris on Bloomberg or on CNN. He's quoted frequently or does interviews. Anytime there's a big IP case, he's very active in the Apple Samsung case. Chris has an undergraduate in engineering and got his law degree from Chicago. Again, a leading expert. Chris and I worked together for a number of years on these issues. So what I'd like to do first is give you some background related to sort of what's really happening in the IP space. And I think a very interesting and important question to start all this with is why the sudden interest in UX IP? Why is there so much money, time, and effort being spent on IP litigation related to UX and on securing patents? And there's been a couple of events that have taken place in the last sort of 4 years or so. The most important being Apple Samsung litigation. And some of you may know this, probably most don't. The $1.3 billion awarded to Apple in that litigation, roughly $1 billion was attributed to violation of design-related patents or intellectual property. So about $300 million was engineering and utility patents. The overwhelming portion of that award was violation of the design patents relating to user experience design. This is unprecedented in litigation and certainly unprecedented in the size of the award related to violation of intellectual property, really specifically UX design. So that case really dramatically raised the awareness of corporations, not only in the US, but across the globe. And so what we now see is this big spike in UX as a corporate asset. So we now have jobs where you see the corporate UX officer, all of these asset bases which were historically driven from an intellectual property point of view by functional patents, utility patents. Now there's this big push toward protecting user experience design. So Apple, Samsung sort of drove it, and then the business world picked up on it, and now we're right in the middle of sort of a big swell of interest in UX. So we thought that tonight would be a perfect time to sort of bring you into what's happening in this space, both conceptually and legally. So if we look at UX IP in context, when I'm talking about IP tonight, what we're really going to be looking at is how do you protect the whole range of attributes of the user experience, naming a brand new hardware design, app development, smartwatch development, desktop software, business process, innovations. We know from looking at the list tonight, there's a number of startup CEOs here. Some of their businesses have process innovations, how to protect that. And then actually, we're going to finish by looking at software code and infrastructure, how you actually protect that. But the key point for what we're going to talk about tonight is we're going to touch on all of these points, and at the end of the day, the major changes taking place in IP with respect to UX is that the best strategies protect the overall user experience. That means intersecting all of these various attributes that are defined as user experience. Okay, so we're going to give you a quick overview. This is sort of really the only legal talk you're going to get tonight, other than some representation related to examples. Usually when, say 5 years ago when we gave this talk, Chris and Beth and I would, there'd be like 2 hours of lawyers sitting at the table, and they would be giving you one legal concept after another with 50 slides, all of this related to specific legal principles. But tonight we're just going to very quickly touch on the protection schemes that are available in the US at a very high level, and then we have a case study. So what we're going to do is look at aspects of user experience design from a specific case study point of view, and we're going to map each of these IP cases to demonstrations that are directly relevant to what you're doing. So no lengthy IP discussions today, just a quick overview. So Beth is going to take the first 3 and explain those technically, and Chris is going to take the last 2 plus 1. So go ahead.
Okay. Hi. Thanks. It's great to be here. So first I'm going to talk about copyright. Many people are very familiar with copyright. You see the notices on practically everything. Copyright is the idea of protecting the expression, not the idea, but the expression, as it might be fixed, is the phrase we use, in some sort of permanent way. So it might be that it's recorded in a movie, it might be that it's written in a book, or it might be a photograph. Copyright covers that fixed expression. It's a very long type of protection, and it varies in the calculation, but it can be 70 years plus the life of the author. It can be very cheap to get. You don't even have to register your copyright if you don't want to, but if you do register it, then you have certain additional statutory rights, or statutory damages, meaning you get a certain amount of money for infringement, and you also have access to the federal courts. The second one is trademark. Again, trademark is something that we probably see in our everyday lives. You might see the R with a circle around it, or you might see the small little TM. The difference is that an R with a circle means that it's registered with the Patent and Trademark Office, and a TM means that it usually is applying for some sort of common law rights, perhaps through a state. A trademark is about source identification for particular goods or services. Trademark is a very old form of intellectual property, and the idea was that if you were going to buy champagne, for example, you wanted to make sure that your champagne came from the Champagne region of France and not from someplace else that was passing itself off as champagne, because we're trying to make sure that consumers are protected from buying a product that isn't what they thought they were getting. Trademarks can last forever as long as they are used. That means that if you have one of these other forms of protection and you can transform it into a trademark, that's very powerful because it will last forever. Trademarks can be registered with the Patent and Trademark Office, and it's an examination process much like for patents. Okay, and then we have design patents, and design patents is my favorite one. And a design patent is the sort of small little cousin of the utility patent, which is what most people think of when they talk about a patent. And a design patent is intended to protect the appearance of what we call an article of manufacture. Typically, an article of manufacture is anything that you can pick up and buy. But articles of manufacture also cover what we call two-dimensional, which in your case would be interfaces, user interfaces. It could be icons. And there are both static icons, such as just an icon that doesn't change, and then there are also what we call animated icons. And an animated icon could be everything from the Apple's page turning design patent to something where you have a wait routine, something that while you're waiting for the computer to do something, or it might be that you mouse over something and it changes. Those would all be examples of animated user interfaces. Design patents are examined by the Patent and Trademark Office. So you send them what you'd like to get a patent on, you have a conversation with the examiner, and if all goes well, you get a patent. Nowadays, if you apply for your patent right now, you will get 15 years of protection from the date that it issues. You would have gotten 14 years if you had applied for it before May 13th, but the law changed. Design patents can be very helpful in terms of enforcement, because there's a very favorable damages provision. And if a party is found to infringe, then the owner of the patent is entitled to the total profits from the article of manufacture, even if the design patent only covers part of that article. So if you have a user interface on a phone, you can, and that you're found to infringe someone else's patent on that, you can get total profits on the phone. And those of you that are in that business know that's a really high profit margin area. So that's how they got to the $1 billion, to be perfectly honest. Okay, so now Chris is going to cover the others.
All right, that was a good summary for sure. I'm left with utility patents and trade dress. Utility patents up there, probably they're next to each other, utility patents and design patents. And just to sort of think in your brain how to sort of compartmentalize these, utility patents protect the way something works, okay? Whereas design patents protect the way something looks. So that's all about aesthetics. Utility patent is all about the functionality of something. Utility patent protects a chemical composition. A utility patent can protect an electronic device. It can protect an apparatus. It can protect software patents. These are all types of things that can be protected. So the key, the operative element of utility patent is that it protects the function, so the way something works. The term is 20 years from filing. It operates in much the same way that design patents do, in the sense that you have to file an application within a certain amount of time. The bar date, there's a 1-year bar date for design patents and utility patents. So as you'll see throughout the discussion here, all of these, they're not mutually exclusive. There's an ability to have cumulative rights across all of these things, and that's one of the things that maybe one of the main takeaways here is you really want to know at least your options that all these things are possible. Utility patents go back the longest of any of these, going all the way back to 1421 with the Republic of Florence, and the Italian city-states, and the architect Brunelleschi, who was trying to come up with a device in order to move things across the Arno, the river Arno, and was able to basically, the Medici family basically said, well, for you to exchange your idea and tell us exactly how we can do it, we'll give you a limited monopoly for a certain period of time. And that's exactly how the system works today. We want to encourage people to, in a utility patent, disclose their idea fully, give them a limited monopoly for a certain amount of time, and have others be able to review that. Whether it works perfectly in practice, that's, I suppose we can have a debate on that. So that's utility patents, protecting function. And the last category there is trade dress. Now trade dress, you probably could have easily put it right underneath trademark. because it's really part of the overall umbrella of it, as Beth had said, a source identifier. Trade dress is where either the packaging or the product itself indicates source. It serves as a trademark. The classic example is a Coke bottle. You look at the shape of a Coke bottle with its contoured waist. You look at that, you don't need to see it to say Coca-Cola, have a name or a logo. You just know from the look of that product that it is that. And whether it could be the Tizio lamp or it could be the Bellini chair, when you look at a certain type of thing, you know what it is. An absolute bottle for vodka. You don't have to see it, you know from that particular shape. So that's the key there, and that now has sort of worked its way into what we're going to talk about more today, UX. It's when you look at a particular home screen, you say, boom, that's Android, or boom, that's iOS. Those are the type of things. Can you develop that type of customer association? The last one that's not on here, it's probably worth mentioning, is this idea of trade secrets. You might also hear about this. This is where you don't access any of these IP regimes where you're trying to get the protection and actually get a formal right on it. This is where you retain it as a secret. To continue the Coca-Cola analysis, the recipe for Coca-Cola. That's never been disclosed in a patent. Had they, after the patented term had expired, it would be free and into the public domain. Rather, they've kept it as an internal secret, and therefore, as long as you keep it secret, it's intellectual property that you retain within. So that basically gives you, as you call it, the manual options, and we'll talk about those. Litigation exposure. Here at every term, it's termed up there, litigation exposure. This is the main thing, is we're going to talk about all these rights and how you can procure these rights, retain these assets, but you have to remember it's a two-way street, because you yourself might go in to get protection to protect these ideas, but also remember that any product, anything you're going to launch out there, you got to be aware, because there's a lot of other people who are going to be seeking to retain these rights. So you got to make sure you don't step on other people's toes. So for every great idea you might want to get patent protection on, you got to realize there's other people who might have already done this already. So you got to make sure, as he puts, litigation exposure, make sure that you're not stepping on other people's toes. You don't have exposure to liability.
Okay, great. Excellent. Excellent overview. Just one thing I wanted to add. Trade dress is indefinite. So if you achieve trade dress, you've got it forever. And a big portion of the Apple-Samsung trial and Apple's thrust was an attempt to obtain trade dress on the configuration of the iPhone and the iPad as well. So there's a complex legal strategy about how you combine all of these. And in that context, what we're going to do is run you through a case study. And we're going to dissect a startup. What we're going to do is I'm going to give the background and sort of set this up in a way that would mean a lot to you sitting in the audience tonight. What I'm going to do is describe the company. And this would be, we're simulating a meeting where I'm the CEO of this startup, and I'm going in to present to the IP team for the first time. So a little background on the company. This product is a new music platform for distribution playback. It was founded in 2012. Combines a combination of branding, hardware, application, some Internet of Things, and some financial services. The company has been privately funded. We have engineering prototypes. We've been testing. Things are going very well. We're looking now for our Series A, which is about 10 to 15 million. They did a small initial funding on Kickstarter in 2013. They have major development partners in China, India, and the US. The founders both worked for Apple and Beats before they started this company. And they gave a major presentation at San Francisco Demo Day 2013, about 26 months ago. They currently have no IP in place. They have some NDAs. The reason I'm here tonight, playing the role of CEO, is we've gone out for our A round, and the first thing the VC say is send over your IP. So it turns out that we don't really have any IP. So I call up my friends, in these big firms, and I say, okay, I got to come in and see you guys. This is the background of the company. I've got to put together some IP, or I'm not going to get my Series A. So I've got to do something serious about this. So this is sort of the background, and what we're going to simulate tonight is what that first meeting would look like. I'm going to take you through a product, and they're going to dissect it and talk about what IP protections would be appropriate. So if I just gave you this, let's say I just walked in, I sent this to you in an email, would you have any response without seeing the product at all?
Well, with this, the red flags, I think Beth and I are both thinking there's a lot of red flags, multiple red flags. One of the things, there was a whole menu of potential IP rights. two in particular, the design patents and the utility patents. You have to apply for those within 1 year of the first public disclosure. The other ones, trademarks, copyrights, trade dress, those ones you don't have to, there's no bar date to apply for them. There's advantages, but there's no bar date to doing so. So, you know, when we see here this initial funding of Kickstarter 2013, here we are in 2015, right off the bat we know that we're 24 months, so we're outside of that. And then the major portions were at this design day, which was 26 months ago, so that's outside of 12 months. So, you know, presented with that, a red flag goes off, and I'll hand over to Beth. What would you do to maybe dig in beyond, that 12-month disclosure?
Well, yes, so definitely the 12 months. Sure, good question.
Yeah, so what constitutes public disclosure?
I was just
Hold on
going
a
to talk
second.
about that.
Hold on a second.
So I was going to say, public is not what you think public is. If Chris and I don't have some sort of contract between us or agreement that he's not going to say anything, he's public. Okay? So that's why when we talk here about NDAs, non-disclosure agreements. Okay, that's great. And people tell you they have them. I would want to see those. I would want to understand, for a couple things I'd want to understand. I'd want to understand what was disclosed at these different times. For example, did someone say on Kickstarter, I have a really great idea for a headphone? But that's all they said. Well, okay, then if people are really going to give you money for that statement, then maybe you're okay. On the other hand, at demo day, if you passed out, prototypes and let people take pictures of them and post them on the internet, then that's a whole other ball of wax. So you have to learn, first of all, what was disclosed, exactly when it was disclosed, and how close what was disclosed is to what you want to protect. Those are some of the basic questions that I would ask, plus I want to see this out.
Yeah, the Kickstarter thing right off the bat, to me, Kickstarter is the killing fields for IP. I see so many people, they're putting their blood, sweat, and tears up there on Kickstarter, and they wait, and it comes around, but it's always after 12 months by the time they get to come back to an IP attorney and say, what can we do? And usually, you bring up a very good point, is, what is the level of disclosure? I've seen some people exercise restraint, but the large majority don't. They just let it all out there because they want to get as much money in. Question in the front, sir.
Yes, Kickstarter is one of these venues, but what about the angel lists? There is tons of angel lists that also require you to put everything on there. Are they also public disclosure?
Yes, if you don't have an agreement not to talk about what you're talking about with the other person, then that's considered public disclosure.
This is an extremely key point. As a matter of fact, Beth and I wrote an article, which is posted up on Medium, related to Kickstarter and IP, which is worth reading. But this idea of understanding the disclosure requirements is probably the most important place to start. If you're approaching 12 months right now and you've exposed your product on Kickstarter, even if you went to your alma mater, MIT, and you gave a demo to a class internally, you've exposed your product, you're done. That's disclosure, you're out there. So oftentimes I didn't realize this was very early on.
And product testing too.
Yeah.
Product testing, you let those people in.
Yeah, get the NDA in place, which would be critical in order to shield yourself from that clock starting to tick. Now, the other thing is we mentioned this 12 months, okay, that you have 12 months, but that also, I think, provides us, a trap is one way to put it, a false sense of security, because it provides you 12 months for you to apply. But what happens is, because we've had a tectonic shift in the U.S. with respect to the IP law, the America Invents Act, we've gone from a first to invent system now to a first to file system. Meaning that before, as long as you were the first to invent an idea and you could prove that you were the first to invent an idea, you would be the rightful owner of the IP. But now we've moved to a first to file system so that we're harmonized basically with the rest of the world. So now it's the first one to file, a race to the patent office. But what we're seeing is people go out there, and this is the design realm, this is critical. They, a furniture show, they show it at High Point, they show a bunch of their furniture, and they wait around. We're going to wait around to 11 months and 29 days to file it, so we just got in the last day, because we only want to file an IP that is our most successful product. But in the interim, every imitator, copyist, whatever you want to call them, they're working away, and they're going to come up with a design, or maybe if it's an invention patent, that they're trying to mimic you or trying to ape what you're doing, And they're going to create problems to your own filing. When you do file in 11 months and 29 days, the patent office is going to look back. Well, where's the closest piece of prior art? Well, it's going to be those imitators who've intervened in the time that you came up with your idea and released it to the time that you filed. There are ways that you can show that they derived the idea from you that won't be intervening prior art. But it's very expensive, and that's not a plan B, that's like a plan X. And the better plan is to file often, file early.
In the context of Kickstarter, it's also very interesting because when you put your product up on Kickstarter and you go to, what you're really doing is opening that idea up to an enormous crowd, an enormous audience. And what's starting to happen now is people are trolling the crowdfunding sites, taking ideas and filing patents. So on those ideas. So what Chris is talking about is really a new form of intellectual property theft, where they're harvesting ideas. And because we're now on the first to file, not first to invent, we're taking those ideas and filing ahead of the invention. So the world has changed dramatically. So let's move ahead here.
Just a quick question.
Sure.
Public disclosure also includes investment bankers and other potential employees?
Unless you have an agreement with the person not to talk about what you're sharing with them.
However, the realities of that are very clear. If you go to a leading VC, they will not sign anything. So that's where things come off the rails a bit. You have to understand that their business is maintaining confidentiality. So that's sort of an informal form of IP protection. You want to be very careful what kind of IPs and angels you're dealing with. But the most important thing is don't put your product up on an angel site without filing. Okay, so let's look at this company. We'll look first of all. This is the name of the company. It's Earrz. We copyrighted the name, and we have a logo. And the logo has an animation. Okay, so this is. Let's just talk about what IP would apply against this very starting portion of the company. What would you do with this?
Well, first of all, you should file a trademark application for the word mark Earrz. You should probably also file, a word mark means that it's EARRZ. It's not a picture, it's just the word. And then you should probably also file a trademark application on this logo if this is what you plan to use. You can also file a trademark application on the spinning portion of the logo. There is typically, because I'm a design patent person, I would say you file a design patent on it. But you can also file what we call a motion mark. You can file a trademark application that covers a particular motion. But you will need, in enforcing that, you would need to show that the consumer associates the motion with the product. So just keep that in mind. You could also apply for the domain name here, Earrz.com, which you do through ICANN. You could also apply for a design patent to cover that logo, especially if you're going to use it as an icon on your product.
So let's say that, okay, we've had this for a couple of years, and all of a sudden this shows up. This is another company we didn't know about when we pulled our URL. We didn't really do a comprehensive trademark analysis, so this company shows up, and this company sells hearing aids. They don't sell music equipment. What type of problem could this present to us?
Sure. So it sort of depends on what the communication is between Earrz, the hearing aid company, and Earrz, the music company is. There's a concept called cyber squatting. So if I apply for a domain name and then I try to sell it to the owner of the trademark, then I could be in trouble for what we call cyber squatting. However, if I actually run a legitimate business named Earrz and it's selling hearing aids, and you run another legitimate business that is selling music equipment, and nobody's trying to, pass off anyone else's on anyone else's goodwill, then I don't think you necessarily have a cyber squatting situation. One of the things that's important to understand about trademarks is that they are for a specific good or service. That is why you can have The classic example is that you could have Apple Records by the Beatles, and you could have Apple Computers. And because they were in different goods and services, that's okay. Now, obviously, Apple's in the music area, so it's a lot more complicated, but that was for a long time the classic example.
Yeah, I think the only thing I would add is Earrz.com is that the likelihood of confusion. Now we're talking about that litigation risk that we're talking about, stepping on someone else's toes. I'm presuming from this hypothetical that they predate the launch of our own Earrz. And if so, are you within their scope of expansion? You know, they're dealing with hearing aids and now you're talking about headphones. Is there a likelihood of confusion between the two? You know, I think that's a fact question, and you know, most likely not, but there's, you want to look at their website. Maybe on the hearing aid website they also are selling some other types of headphone type of things. So it's something that you need to tease out. But I think the moral to the story is, when you're going to be launching a product, you need to tease out every one of these types of, or have, you know, an attorney, or you know, even just be aware of these things probably, of each one of these categories. The copyright, by the way, wasn't implicated here because there's a short name. You can't get a copyright on a name, on a short name or title or logo or slogan. It's got it, so that's why copyright didn't apply. And nor with the design itself, the copyright doesn't come into play there. They're not going to say that that's original enough in order to meet that. There's not enough expression in that logo. It's basically a simple logo.
So this raises one other thing that may not be something that some of you are familiar with. Before you pick, many companies, before they pick the name of their product, they run a trademark search to see who else uses that name or a similar name. A lot of smaller companies don't do that. They just think of a cool name and kind of run with it. But the bigger companies, before they name a car or a drug or anything sort of major, we run a search and we see what the candidate possibilities are. You know, these are our top, this is what our branding company tells us are the top ones. And then you run a search because it's important to know about Earrz with one Z or with one R before you get too far down the road in picking your company's name.
So, another question. So, what if we get a cease and desist letter from Earrz.com? How do you respond to that? They send us a letter, their lawyer said, you're infringing on trademark. We want you to change it up.
Yeah, I mean, I think, so initially you're going to get a letter like that. I would also, the advice would be simply, you know, also to engage an attorney early in the stage instead of responding something back. You just might not realize what just flew out of your mouth out of the letter that you're sending. You might be making things worse. But I think one of the things, if you're responding to such a letter, is find out, are they actually registered? If not, any instances of actual confusion. I mean, that would fight. If it's not registered, their trademark, because you don't have to have a registered. If I begin selling gym shoes down on the corner of you know, Broadway and Liberty, and I could call those Chris's gym shoes, and that could be my trademark. I don't have to go register in Washington at the Patent and Trademark Office. But if I want to get nationwide coverage in my rights, then I would want to go and register it, because that would perfect your rights nationwide, also give you access to courts. But there you would have an indication of what you think is the scope, the metes and bounds of your trademark, because it will have a description of what I'm applying it to gym shoes, but I'm not applying it to ski boots. Okay? But in one of these situations, if you receive a cease and desist letter and it's not registered, you need to find out what do they think is the scope of their trademark right, and then I'd further inquire what instances tell me any instances of actual confusion, because here it seems like apples and oranges. We're talking about headphones compared to hearing aids.
Okay, so let's move on. What I'm going to do now is I'm just going to take you through the whole product. So there's a headphone product configured like this. There's an app which interfaces with a headphone set. There's a music application, desktop application. There's a process model. There's some process innovations in here that are very important related to the acquisition of funds through Bitcoin and how musicians can be paid, compensated. There's the actual machine code, which is running in the background, of course. There's an Apple Watch implementation or smartwatch implementation. And then there's the Earrz Cloud. So this is a typical sort of presentation that you would give to your IP team, your IP lawyers for the first time. This is sort of a schematic overview. This is the whole user experience. And the reason that you do this initially is that you want to establish the palette or the full extent of the innovations in which you're putting forward with respect to this particular or new company. So this is kind of the scope of what these innovations cover. I just like, a very quick first impression of the complexity of protecting a system like this if it's at this stage of development when I first come to see it.
Well, again, this is, what I'm looking at is that the client is at this stage where they're this far along. I'm thinking both sides. One, procurement, where's the IP that we can secure? But then for every one of those rights where it's possible that there can be an IP right that I might advise to get, I'm well aware that on the backside, somebody might have already gotten those rights. And if you're going to launch this product, there's a whole lot of landmines you might be stepping in. So you're making the client aware of those two things. But I pretty much, from looking at this, I think we'd all agree pretty much every one of those IP rights that we've discussed could be implicated, from trademarks to copyrights to design patents to utility patents to trade dress to even trade secrets and certainly litigation exposure. So at the highest level, that's where I see it.
So, I think that Chris is right, but what I would say is, I would be concerned if the company had actually built all of these things. Yeah. If a client came to me with this idea but hadn't actually built anything yet, that's actually a really good stage to talk to your patent attorney, your IP attorney. And the reason is that the sort of old school model of IP protection is something called the invention notification form. And this is when someone who works at a big company, big co, comes up with a great idea and fills out the form. And then it goes to a board that looks and decides which things we're going to patent, and then it goes out to law firms usually who prepare the patents. It's a very stovepiped way of thinking about your IP, and what we end up with is you end up in situations where now, as Charles will discuss later, it's much more difficult to protect software patents than it was years ago. And sometimes people say, oh, well, if I had understood it was going to be hard to do this, I could have protected other aspects of the IP, but now that ship has sailed because the year has passed. So when someone brings an overview like this, it is actually very helpful because your attorney can help you develop an IP strategy and say, have you thought about this? Have you thought about using design patents for this, or trying to use a trademark for this? Because at that stage, you can actually, I think, get the best bang for your buck in terms of your probably limited budget for these IP rights. And the other thing that's important to understand is that IP rights mature at different times. So it may take you 2 to 5 years to get a utility patent. It may take less time to get a design patent. You'll get your trademark perhaps earlier. You can get your copyright right away. So what you can try to do is organize your rights in such a way as to always have at least some protection, so that you're not just waiting on that utility patent, which might come out in 4 years.
Okay, so let's, what I'm going to do now is just look at each of these individually and get some feedback. So this is the headphone configuration. It's got lots of innovations in it. Music is retained in the headphones, not in the specifically in the app on the smartphone. The music controls mimic the logo type, so you can tweak the layers, you can set the volume, change the tracks. It's got a high-resolution camera. It's an accessory that clips onto it. It's got a lightweight carbon head strap. So you can custom print the 3D ear pads here. And it's got a voice-activated UX. So you can function with this device using voice instruction. And voice instruction can be mapped through the app to IoT. So let's say that you want to run some other aspects of your, other pieces of technology, like your Nest thermostat, for example. You can run it through this sort of verbal interface or audio interface. You have a question?
You mentioned a moment ago that the rights mature at different rates.
Yes.
Could you expand on that a little bit? Like what drives that?
Some things are a registration process, like copyrights, so they're pretty quick, 3 to 6 months, I think. And then some things are an examination process. Some types of rights are just harder to get out of the patent office. The patent office is more crowded in certain art units than in others. They divide everything up into the different technologies. And I mean, there are ways to pay for faster processing. Almost every system has an expedited version, but that's going to cost you even more money. And depending on how important the technology is, that's what I said about your budget. we can do a lot of things if we understand your timeline and we understand what's important to you to protect.
So I guess we're going to understand that it's a first to file system. So what if it takes them 3 months or 6 months? No one can steal that stuff, right?
Right, so you can't enforce the right until it issues.
So someone else could build it and they can be in market in that.
From the time that your patent application publishes, if your patent emerges from examination substantially similar to the way it published, then there is an opportunity to get a royalty on things that happen in the interim. But again, it's uncertain. You'd have to, go. You can't, just because you have, this is an important point. Point number 2. Just because you have a published application does not mean that you can write a cease and desist letter to someone. You can send them a letter advising them of your application, and people do that, but you don't have a right that you can take to a court until it issues, either as a patent or a trademark. Well, trademarks you have common law rights, it's a little more complicated, but generally speaking, until something issues, you can't enforce it.
No, that's fair. And so, just to give you maybe some tangible guidelines here, a design patent issuing from the time you file it until issuance, somewhere between 12 and 16 months. But as she mentioned, there's ways to expedite that, where I've seen some as early as 4 to 6 months from filing to issuance. So, rather than having this pending phase where you really don't have any teeth, you can't really do anything, where on a utility patent, it could be anywhere from 36 to 48 months, okay? So it takes, even though they publish them at 18 months, that's just publishing your pending application. You don't have any rights. So the thought here is, get some copyright protection. If it's available in all these things, you can get that quickly, almost instantaneously. Then you can stage it where you have your design patent protection. You have maybe some trademark protection you're building, because that is incident upon use. So trademark protection, trade dress protection here, you have to, in Coca-Cola, that didn't happen day one when it hatched, when they first made the first Coke bottle. It took many, many years to develop that, or shape all of a sudden becomes your trademark. So trying to layer these protections.
So do you have an opinion about?
Well, I think that raises an interesting point about this particular design. Let's say that as a company, you all have decided that you're very committed to this side piece with the controls, because that's your logo and that's what you're going to do, and you think that even though you might change other elements of the headline, of the headphone, that's your thing. Whether it's this version or the 5th version, it's gonna have that shape. Well, then maybe that's something you want to invest in getting a design patent, because that's something you plan on using for a long time. If you say, well, we might decide next week that we're going to make the head strap wider or thinner, then maybe that's not the thing you choose to protect, because you want to think about what you're doing at the end when that right comes out, and whether or not you may still be using that design or that technology. One of the things that's really interesting about utility patents is, especially in the electrical area, for computers, people don't, so they last for 20 years, but that's if you pay the fees. There's some fees you have to pay later on. Some people don't even pay the last set of fees, because they look at it and say, well, that piece of technology, that boat is sailed, no one's using that anymore, I don't need to pay a couple $1,000s to protect it. So it's important to be sort of forward thinking about these things.
So I have a question for you. In terms of,
That's a question.
So, pertaining to the diagram that you have out there, let's say that you hired a UX designer to create this, and they want to use this setup as part of their portfolio. So they have an NDA, so they're not going to use the same thing, but they create a similar sort of schematic. Are you still, able to go after them for doing something similar in their portfolio, or is that sort of not something that you can have?
I think I can answer that because I see a lot of portfolios. The answer to that is you tie them up as tightly as possible. Do not let them show what they designed for you in their portfolio, because you have no idea where that portfolio is going. And that goes to the issue of agreements, employment agreements, which we're not discussing tonight at all. But you never want to let a freelance designer create product for you and then have open exposure to their portfolio. Absolutely not. You're toast if you do that. So one quick question before we move on. Can we patent or protect voice-activated UX? I mean, is there opportunity for that kind of protecting those kinds of innovation?
I think, we're looking through a utility patent at this point. It's sort of the functional idea of a voice command being received by something, a microprocessor. processing that and then executing some type of some activity. That's something that's potentially, there's been a lot of efforts to curb that, but if it's tied in some way to some type of machine itself, there is possibility to do it, but that's been greatly curtailed in view of an important Supreme Court case, CLS Bank v. Alice, that came out last year. Again, I don't want to get, we don't want to get too deep in the weeds, but the point being, I think generally something like that is possible, including hand gestures. We just saw sort of an important case where there was ideas regarding pinch to zoom and double tap to zoom that was sustained. And I suppose that as an aside, you read so much in the mass media when they're talking about IP, and there seems to be the sense of frustration. Oh, that's that's old. That's understand that by the time that something was filed, then it takes 4, maybe 5 years for it to issue. Then by the time it gets litigated, we're looking at 10 years out. So when people get so frustrated in the mass media reading these stories about somebody's got a patent on this and they're trying to enforce it, put yourself in a time machine and go back 10 years and then ask yourself, was that novel then? And that's really the operative question.
One other quick thing is you can get trademarks on sound. So like NBC, and I'm going to embarrass myself, but does dun dun dun, like the NBC, that they have a trademark on that very, very brief amount of sound. So you could, if you had some brief amount of maybe response that the system gave you when you made your voice command, that potentially, again, if the public comes to associate that with these headphones and this product and that company, then you could get a trademark.
Okay, let's look at the app. Okay, so again, the navigation on the app, we use the spinning wheel again. So it's a typical spinning navigation tool. You spin, you can find the music. Question, are we infringing the iPod if we use that same interface modality?
It's funny because when you see this, the UI, the GUI is placed on what appears to be either an iPhone 4 or 5, I'm not sure which one, but that is sort of a red flag to myself too, and I see that used all over, even in advertisements. People are sort of using that as the generic symbol for a smartphone or something like that, and that always to me would say a red flag whether we should be using the exact look of an iPhone as opposed to more genericized look of a smartphone. But relative, if this was the only 2 pieces of information, and this was, you're saying a design patent is what's on the left side of the page here?
I'm just saying, I walked in with that, and my interaction modes are the same. They're both using circular navigation.
Yeah, just using the circular to the circular, and not just whoever's owns this right on the left there, it's going to be the overall appearance of the device, okay, if it's claimed like that, so that the overall appearance of the 2 things don't look the same. Had they just claimed filed the design patent just on the circular portion itself, again, I question whether or not they would have been able to get that, because unless it was, from the beginning of man, there was probably circles out there. But if they were to have gotten that, perhaps there would be an issue, but I suppose then I would look at the design patent and say, is that design patent on an electronic device, or was the design patent claiming a display screen showing that? Because after all, that's what the accused product is showing here. It's a UI, GUI. It's not actually a physical click wheel that they're trying to do. So my general sense would be no.
Yeah, it's not a very good case.
Okay, so let's talk about the design of the interface itself. Let's focus, for example, on these 3 buttons. When you created let's say the patent application for this, when you create a patent application, if things are shown in the dotted line, that means they're excluded from the patent. So by definition, what would you have to exclude from the design of this screen, from a design patent point of view?
So I typically exclude all words, because you may put it in Spanish and then it's going to be in a different word. So I do that. I also exclude everything that's going to change regularly. So if you have graphs or things like that, what you want to focus on is the heart of your design. And to me, the heart of this design is definitely the sort of centerpiece there with the red bits, I don't know what you call that, and possibly the button at the bottom, but I wouldn't include the words. And that would, at the same time though, because the client seems like they're going to repeatedly be using the top portion, that might be the only thing I would file on. You know, I don't think you have to, we don't typically do what we call a picture claim. So like we wouldn't turn this into a design patent. That's usually not a very good design patent. You want to be careful about selecting the items that you choose to claim because you don't want to give the competitor an opportunity to make some very small changes and get around your design patent.
So let's just look through this. So we use the spinning wheel here.
We also do it in black and white. So like we could claim that in black and white, which would then cover that next version.
So this is a whole sequence. So let's say, for example, you choose Earrz. You got the last screen here with music, money, and magic, and the icons on the bottom here for your services. So this is a process flow. Navigation, identifying an element, flowing to the third level of navigation, and then sub-navigation. Can that flow be protected from a user interface design point of view?
Yep, the flow, just to be clear here, when you're claiming this, you will show the industrial design in dotted lines. We're just claiming what's on the display screen. So you don't want to be limited to you know, a Galaxy or an iPhone or a Razr or whatever it is. So everything that's seen on the outside is going to be a dotted line. We're just talking about the screen. As Beth pointed out, black and white is generally how you would claim this because you're trying to sort of genericize it as much as you can. And then as far as the flow, as Charles has called it, more typically you might hear it referred to in patent parlance as a transitional GUI or as an animation. Yes, you can claim one screen to the next. I always think of it, and the way you're doing it, the USPTO does not accept MP4s. Their only office I know is the Korean Patent Office actually accepts a little MP4 file to show it. Well, right now, we're stuck with 3 static line drawing images, black ink line drawing images that you would show from each one of those stages. She mentioned the page turn. It reminds me of when you were a kid, you had the little note cards and you're trying to show a horse galloping or something like that, right? And you just sort of show each one of those frames. You might file 5 frames, 10 frames, whatever. I think there's a strategy as to how many frames to show too many or too less, because the more you show, the more narrowing you're getting your claim, showing that every motion of the horse's legs that you're claiming. So but you want to show enough where you're actually communicating that sense of motion. So here in any animation, it seems like there's an infinite amount of frames, and you have to exercise some restraint and strategy, and employ some strategy as to how many you want to claim.
So just one more point. You could actually file these 3 pictures with the patent office, and it's very possible they would give you a design patent. It is a nearly worthless design patent because it has so much detail in it, and someone can make small changes, and we're not showing a genericized flow of how this UI operates. We're basically taking screenshots, and then the patent office will they'll take your money. They'll give you a patent. It'll look lovely. You can give it to someone as a gift. It's not really going to do you much good. So it's important to sort of take a step back and think kind of one layer below what's actually on the screen and try to protect the underlying shapes and forms. That's what you want to focus on.
Let me just on this one point here is that I think the other thing to keep in mind is that this is we're saying a patent. I mean, if I were really digging in here, and then it's all about what type of resources that you have. But to really protect something like this, I would think sort of in 3s. A general patent claiming the overall appearance of the design, and then get in there and try to pick out some of elements. Okay, maybe the upper portion and the middle red sort of scalloped portion in the middle, and maybe a combination. Try to think of those things in couplings of individual sub-elements. Because if you claim the whole thing, that's like having a utility patent that claims A, B, C, D, E, F. Okay, well, people could just change things on the margin. But if you claim some of the building blocks of your design, okay, I think just trying to claim the circle is going to be too much of a fundamental. You're going to run in. The broader you claim it, the more prior art, the more chance you're not going to get your patent. So it's trying to find out these different levels of scope. And don't be surprised if I always get frustrated when people get one utility patent, but then when it comes to design patents, they say we're going to get one design patent. The reality is a utility patent has many claims in it. A utility patent can have at the end of the patent, you get to the very end of the document, there could be 50 claims in there. But a design patent only has 1 claim. So I always ask clients, I say, when's the last time you've seen a utility patent with 1 patent claim in it? Never. You've never. I mean, I can't even think of one. I've never seen one. I've been practicing almost 20 years. I've never seen one with one. So the point is that for utility patents, the effective strategic approach is to get several design patents covering different aspects of it. And this is, you know, I don't want to. We're not going to talk about Apple, Samsung. At least I can't. But I would say that that might have been an approach that was effective.
I agree with you, Chris. I think that's very interesting. But what's particularly interesting to me about all of this is that there's so many apps that are extremely innovative and they have no IP. And it's really not that complex to look at an app. Most apps are relatively simple in terms of their basic interaction structure. To employ an IP attorney to decouple the high-level design and reduce it to its primitives and secure a patent on that, assuming that it really has those kinds of innovations. And you really will have protection that you wouldn't have before. So I have another quick question. So,
So you said you advise not to use text on buttons in these diagrams. Do you supplant that with annotations? You know, we're UX designers. We live to detail this shit with annotations. So like, where do claims and annotations begin? How do those two concepts come together?
let me sort of answer that briefly. The idea that Chris made that design patents have only one claim, what's very important about that claim is the image. That's what's important. There are no written claims in design patents out of that. So you take the headphones, for example, you have 5 views. You have an orthographic perspective, front, top, side, all of the other views, and that's it. And when you go to litigate against, or Beats comes after you, and you go after Beats or whatever, that's all that the experts are looking at, that's all the lawyers are looking at.
Right. But when you look beyond that, you presented this as a flow.
Yes.
And that looks like some pictures to me. That's not a flow. So like I don't know what that is. I wouldn't know. I wouldn't understand your intent when you show that. So it's hard for me to put that in the context of for example, the work that I do with clients and coworkers.
Sure. So that would be the way the design patent is structured, the way it's drawn and written. And if you apply for design patent, lawyers would teach you how to read those patents. And the opposing experts or the companies that have a similar design, they know how to read those patents as well. It's not, let me just say, as a designer originally by training before graduate school, a lot of it doesn't make sense. It's difficult to understand, and it's counterintuitive from a design point of view, but it's the best we've got.
Well, just to specifically answer your question, what do you do with that text? You know, it says dot out music. You would put it in dash lines, music. So in other words, it's not claiming that specific text. I've seen other people, and let's understand too, we're in the nascent stages of all of this, as far as how to claim it in the actual documents, the patent itself. I've seen people, some put X's in there, 5 X's, indicating that there is text in that place as a marker. I've seen people not put anything in there. I've seen other people put sort of a boundary line on the inside saying what's inside of this box is not specifically being claimed. So different ways. I think best practices are being developed sort of real time right now, but something in there other than what Beth is sort of guarding against is limiting yourself to the word music as opposed to music or musica.
Take a video of your idea, of your UI, someone using your UI, and then show it to your attorney, and they'll be able to give you helpful tips that are real. This is sort of hard because it's a little disjointed, yeah. We got like all sorts of questions.
So here, what happens if somebody puts, so there are like 3 servers, and I come up with 4 servers. So what's the difference? So there are...
So the test is an overall, it's a substantial similarity of overall visual impression. So if you go to one extra round, that may still be substantially similar. And what we haven't talked, what we haven't talked about is that it's in the context of the prior art too. So of all the prior designs that came before. So to some extent, and I feel like I've just taken a deep dive into a deep pool. But the point is that I think for design patents, you should protect your product well, but not overly detailed. And then that will serve you best in the future. It's hard to prepare for every possible eventuality. But if you have the patent, hopefully what that will do is convince people to pick a different design. Because I don't think what you're trying, I mean, to me there isn't a situation where people are saying, I'm going to go out and sue you because you stole my design. It's more, please do something different. You've confused people, they think it's my stuff. I don't want you to think it's my stuff. Please do something different. And I think that's what happens with a lot of design patents.
Yeah, I mean, of course, some people might get overbearing and say, I own the rights to circles. You know, and that's problematic. So I think when you're looking at that, you're asking the question, which is the million-dollar question, how close is too close? All right, and I think only the way to get that, you know, Beth and I, between two of us, we don't work together at the same firm, but I'm sure we've looked at probably thousands of situations where we've seen an accused product relative to a patented design and trying to determine you know, how close is too close and trying to understand when it is. And ultimately, it depends on a couple things. One, what the prior art looks like. Is it a very crowded prior art? You know, in a gym shoe design, there's so many gym shoes out there, a small difference will make a big difference, okay? Or in other words, say for instance, do you and I look like each other? Compared to a pack of elephants, we look very much like each other.
Yeah.
Compared to your twin brother, we don't look alike at all. So it's all relative to what? So that's why we have to put it against that backdrop, that frame of reference. The other thing is what has been claimed. I like the example of where if you claim the entire United States, and say down in Florida, there's you have this a bay or something like that's down there. Okay, just think of this visually for a moment that there's down there. If somebody else comes out with a similar map of the United States and that bay is not there, whether or not that bay are there, it doesn't really matter. But if you were only claiming just the state of Florida, okay, or just Dade County, and that's where that bay was, then all of a sudden that difference makes a big difference. So if someone just claimed the circle and there was that little knob on the end, that makes a difference then. So that sometimes the less that you claim, okay, so that there's only so many places for difference, then smaller differences matter. So I think the point being is that there's a certain relativity to the analysis.
Yeah. Let me just answer that question because it's not totally clear. There's an actual legal test for determining degree of difference. It's actually written in the statute. It's called the ordinary observer test, and it has a very specific written description. And all these cases revolve around the similarity of differences in application of the ordinary observer test. So that it's written, you can go to the USPTO site, you can look it up. That's what experts do. And there's actual now, there's an evolving science around how different is different. And it's becoming much more complex. It used to be, you give a couple of experts and one would say it's different, and one would say it isn't. But now there's actual cognitive science related to how those differences are determined. So I think we need to move on, or we're not going to get done. So just very quickly, would any of this infringe the iPhone?
I don't think so.
Okay.
It depends on the claim.
Yeah. So let's just think. I mean, the claim itself. Okay, so we're talking just about the UI, right?
Correct.
We're not talking about the industrial.
No, just the UI.
Okay. So I think the key there is, you know, you've got basically that positioning of the rows of the icons, the containers, as they're called in icon vernacular. But here, where that was what was claimed, as Beth said, if that's how it was set forth in the patent, showing, you know, 4 rows, 2 on the bottom, 3 on the bottom, it's the entire, look at the overall appearance. So the overall appearance, which is in that image on the right, is that same as the overall appearance, which is in the Earrz arrangement of those? I would say no. This is, because you have a claim, you have to look at the overall to the overall. This is not like copyrights in literature. You could have a 20-chapter book, okay, and if I copy word for word chapter 17, you don't, but then the rest of my book is different, it's enough that you copy chapter 17 for there to be infringement, okay? But in a design patent, it's the claim is the overall thing that's set forth in your design patent. To the extent that that's not the same as what the accused product is, at least on this hypothetical, I would say no.
Yeah. Okay, let me just clarify one thing. When they say the overall, comparing the two products from an overall point of view, they absolutely do not have to be identical. They have to give the same overall impression. There can be significant differences between designs and print, and oftentimes there are significant differences. But they don't rise to the level of creating a different overall initial impression. That's the key that you have to keep in mind. Okay, let's move on. Okay, so this is a desktop application. Now, question here though. This has been programmed up. So let's see here. This shows up when you go to talk to your IP attorney, and your IP attorney says, wow, that looks a lot like iTunes. Okay, so it turns out that this is exactly the same page structure, but it's a different visual style. So, talking now just about litigation exposure. Looking at these two designs, does this company have litigation exposure? If they use exactly the same page structure in their UI, but they restyle it essentially from a color point of view.
So it depends on what protection Apple has in that interface. Do they have a design patent? That could be a problem, because depending on how they claim their design patent, if they haven't used color in their design patent, then it doesn't matter if you have different color in your user interface. Now, if they don't have a design patent, and instead they're trying to rely on some sort of trade dress rights, then it depends on whether those trade dress rights are registered or not registered, because there's certain requirements for trade dress, and one of them is they have to show that it's not functional. And so it's a more difficult type of case to make, and it would be harder for Apple because there's more sort of bars, or there's more hurdles they have to get over in order to show that they have the appropriate rights to be able to assert against Earrz. Now, that being said, if I'm advising Earrz, I would tell them to pick a different design. I would say, listen guys, there's no reason you need to go poke a tiger. Like, that doesn't make sense to me. You should just pick a different design. And, you know, that, if you're worried about it, that might be your best choice.
Okay, so let's move on now to process. So this, I'm just going to run you through this process. This system would be based on micropayments. And the idea here is to disintermediate the music companies. So the user can purchase Bitcoin currency. They can use, the artist can use Bitcoin for other services through the actual interface. Users have full access to making these micropayments. Bitcoin micropayment can be stored offshore, so the artist can make use of it sort of in a tax-free context. The artist can use the digital rights to rent purchase services tax-free. But it has one innovation from a process point of view. We all know that musicians have problem with cash flow. Cash flow goes up, goes down. So if you're paying the artist, and the artist is receiving Bitcoin, the artist can channel a portion of their payments to income smoothing, which is a financial services account. So the money goes into the smoothing account, and then Earrz would schedule payments to smooth out your cash flow when you don't have money. So this is a process innovation. It's a conceptual innovation that is executed in code, obviously. But the question for Beth and Chris is, this is a process that we feel is innovative enough that we want to secure the rights. Can we do that?
I think you're going to have a hard time securing something like this. I think one thing to understand about now, this is hitting at this idea of software patents. It's a tumultuous time. I mean, we're having a lot of changes in the law. So if you're looking for certainty and you're saying, I'm going to plunk down my 10, 15 grand to try to get a patent and pursue this, understand that that law is changing. So even if you were to secure those rights, and I'm thinking harkening back to even 7, 8 years ago, somebody in this particular area, that they're being sort of a newer stage. Now we've had some Supreme Court case law that's come out that's made this sort of curb this and shed sort of a negative light on this type of stuff. But this is, I suppose, it would take some clever approach to try to find it. I mean, look at, like, for instance, Uber with ride sharing. Some people might take a jobless approach and say, no, you can't get that. But there are certain ways that you can tie it to more tangible events and not just sort of these more ethereal type things about just ideas that you're talking about. You can more tangible type things. The movement of the And even things like iTunes, you know, that process of clicking on things and selecting music and hearing samples, there are a lot of utility patents that are on types of stuff like that. It's all about the time period that when you were trying to secure it. So now would something like this be patentable? First thing out of the bat, I would want to do a search, as Beth said. You know, that would be the first advice before you start investing and trying to draft claims, only later to find out there's something out there. If we were in a time machine and we went back 15 years, I think we'd all think, wow, that would be a pretty cool idea 15 years ago. So it's all sort of has to be put in the context of the timing. Once you get to tax things, there are expressly specific exclusions or prohibitions for software patents on things that are regarding tax schemes, tax havens, that type of stuff. There are tax programs. Those are expressly eliminated from protection. But other things, I think it's possible, but I think it's going to be enough of that.
I would spend my money elsewhere.
If you did have a really innovative process, would all you need to do is that to protect it? A bunch of boxes?
Yeah, and you write some paragraphs. Well, the way they used to work 10 years ago is you do this, and then you write some paragraphs describing this. But those are, the people who, so what happens is if you have one of these that you got 10 or 15 years ago and you assert it against someone, under the new patent laws, the someone takes it to the patent office and says, this is not patentable subject matter, it doesn't meet the statute, and then typically there's a board at the patent office that looks at this, and they've just been cutting these patents down left and right. So you might get it, but you might not end up being able to do much with it later on.
Yes, and
So,
for,
what else would you need in addition to this to make it
well,
patentable?
let's go to the next example, because the current best thinking is not to try and patent the process, but to develop a UI across which the process runs. So you would develop this sequence here describes the sequence which you saw in that process, one flow through the process. So what we do is use design patents to secure intellectual property against the underlying process, which you probably cannot copy. So it's not as good as a utility patent, but on the other hand, if this flow is very powerful and engaging and reaches both a design patent and trade dress, you have protection essentially on the underlying process. So this is probably the most advanced thinking currently in how UX is actually impacting the net worth of these companies. We're not going to get these process patents any longer. They're being cut out by the Supreme Court. So what we need to do now is take the UX, sit it on top of the process, and protect the UX. So that's really the thinking. Go ahead.
Yeah, I would look at this, you know, through things that are knockoffs and lookalikes, and then you're trying to extend that out. We as patent attorneys, particularly in the design context, you're taking, okay, I want to protect the exact idea, but then trying to see if you can broaden that or have it such that it might stop other types of assimilations of your idea, not just your exact. I mean, yes, you would want to stop this if someone were to come out with your exact same look. You know, that's one thing I usually ask clients. Is it worth going for this protection? Well, if the very day you release your product, the very next day somebody came out with the exact same look to your product, would that upset you or your shareholders or anybody else? And if the answer is yes, then you need to get protection. Because if you didn't get protection, no one's going to hear you when you cry that someone copied your exact design. In fact, the law encourages copying if there isn't some other IP right in place. So, you know, here, this is one way to do it, of course, you know, trying to get that broader protection. So if someone doesn't execute it in the same way, that's sort of the trick, right? Trying to broaden it up so it's not just limited to these particular shapes that are shown up there. But some stuff, you know, have become almost standards. Now you look at it, you think, oh, now it's so commonplace, but maybe a slide to unlock or clicking a upper right corner to close a box or something like that, or a particular hand gesture when the thing moves to a particular corner. Those things might seem like they're very specific, but now they've sort of become more commonplace, but they could be valuable at that point in time.
Yeah, the other thing you can do is try to tie your business process to a piece of specialized hardware. So if you have don't just think of the Nest icon or the Nest app separate from the Nest thermostat. See if there's a way that you can tie the two together, because the patent office takes a much kinder view of physical things that they can sort of feel like they can touch that are related to the business processing.
Yeah, and that's the context of this model where the headphones are tied to the business process.
I have a question.
Yes.
In this particular scenario, if you had an algorithm for how you loaded the money, would that allow you to have the process?
Probably not.
Yeah, I think.
But let's say that you had a system where there was something you could touch on the headphones, right? You love this song, and you're like, I love this song, I want to give this artist another nickel. And you push the button. That might be enough, because you're now connecting the hardware to the business process. And then you throw in all the other stuff too. But I'm saying, like, you have to have something that separates it from just being something that someone could do on pen and paper in the human mind. It has to be, something sort of more than that.
So, but question to that.
Go ahead.
Would it be time? Let's say I do pay, instead of payments, think of coupons. They're now digital, but I can print. Do I need to have the print so that it's tied to a physical, or just being digital is enough? It's a fuzzy area. I mean, a lot of things are, like Bitcoin is digital. So.
Well, what they want to prevent is just people saying, taking anything that can be done in the physical realm and then putting it on in the digital realm and saying, okay, now it's new. Yeah, it is, but they're saying that that's not satisfying. But tying it to some type of machine in a more specific way, other than just taking what can be done in the physical realm onto the digital realm. But it's much more helpful when you have specific hardware, like the Nest thermostat or something like that. Something on a car dashboard. But if it's on a smartphone or computer, they're looking for some type of physical act, some type of interaction with the computer itself.
It's a very interesting problem in this particular space right now, is this transfer from physical world to the digital world. And what is actually that? Fine.
So where does the actual action that a user takes in here? I mean, do I hit that E to make it go to the second thing? Do I do a circle? Do I blow on those ear things like a pinwheel? I don't see where that's being represented or protected. I mean, you haven't told us that yet.
Sure.
In a static design patent, that would have to be described in the animation.
But I thought you couldn't put in an animation.
In the sequence of images that are presented.
Yeah,
So
in
if
the
it was
description.
blowing, I would have lips there with wind coming out in the picture. I don't know.
I would show the results of the blow.
Yeah.
But the results of the blowing could be exactly the same results as a can.
Yes. So then you get a patent that covers both hands and blowing.
Yeah, I would, to just be clear, so, design patents, utility patents. So design patents is covering the visual, what you're seeing, this type of evolution or this type of transition. If you want to talk about the input device being, you have a candle, a birthday candle, someone says do something, and then you blow it. I just came up with that idea. And you blow it out, that the candles go out. I think that's something that you might be looking for on a utility patent claim. So design patents, visual, utility patents, here's some type of functional interaction that's claiming. There, it might be you snap your fingers, it might be some type of oral sound, the blow that's going on. That's what you're going to have to specify in the utility patent. But in this example here, what's being shown here is the visual design part, but a utility patent would have to claim the interaction.
Yeah. And to be clear about that, Glenn, the IP system currently as it's structured does not do a good job of interaction. Because you have to write a utility patent that addresses the functionality, or a design patent, which is essentially static presentation of images. So, in fact, you want to talk quickly about some of the design patent or UI work in other countries that's going on right now. Like China, for example, they just instituted the ability to design, to protect GUIs. For years in
But
China,
you have to show the device.
Yeah.
So it's a problem. It's not so much a problem for Apple because they only sell a few devices. But if you want to try to protect Android in China, that's very challenging because there's so many different devices that can run Android, and the Chinese are telling us you have to show the underlying display device as part of your claim. Now in Japan, you have to have a display device, but you don't have to claim it, so it doesn't really matter what you pick. But different countries have there's an evolution, it seems like, where most countries start with, you can't claim it at all, you can't cover GUIs at all. Then you can cover GUIs, but you got to show the display device, and then they kind of work their way towards the display devices. The GUI can be protected independent of the display device.
So sometimes you'll just see the screen. Other times, country will say, well, this has to be tied to an article of manufacture. We don't want to give a design right for just an image. This is not like a copyright on a portrait or something like that. So they'll say, okay, what's the article of manufacture? It's an electronic device. All right, well then show it in dotted lines. Show us
That's
Japan, Korea, show it in dotted lines, and then you're going to have the GUI actually on it. But what China has recently done, they took a baby step. They just started allowing us to claim GUIs, but they're requiring you to put the industrial design of the device in solid lines. But you can see how limiting that is, because you have it on one particular phone, and someone just takes that same GUI and puts it onto a totally different looking phone. And when you do the infringement test, you're not just looking at the UI to the UI, you're looking at the UI plus the industrial design compared to the UI plus the industrial design of a different phone. So again, the law's evolving. Every different country is different, but that's sort of what we spend our days whiling away.
Okay, so let's look at code protection. This has been a topic of great interest for a number of years. So in this particular company, they're based in the US. They have partners in China, India, and Russia. All of these partners are writing code, underlying code. Russians are writing security code, Indians are writing the database work, China's doing the hardware interface and the firmware. So how does one go about protecting the code base? And what are the trends, and is that even possible?
So here again, it's sort of, we're talking about software patents and all the travails of trying to protect that through the patent system, which has been greatly curtailed in recent years. So you're looking now at protecting source code through copyright, and of course, the common refrain from coders and programmers is, there's obviously a lot of people who think you shouldn't be able to protect it at all, sort of the open source crowd, but there's a lot of different ways to express. Anyone who's done any coding or programming knows that any particular executable can be done in many different ways, and you probably just change it very quickly. So yes, you can submit a copyright application, but would stop somebody from copying. After all, that is the operative word in copyright. It protects other people from copying, just cutting and pasting and popping it. But if somebody uses different code, they can easily circumvent the source code. That's sort of this conventional wisdom. One of the cases that's going on right now is whether or not these APIs, which are sort of the building blocks, and trying to, again, broaden it up from just not trying to broaden up the protection, not just from the literal source code, but maybe some more of the building blocks within the code itself. But that's sort of the challenge.
And this raises one other thought for me, which is that you need to keep track of, from a patent perspective, where the inventions are made in the world. So if you have a group of people in your startup, and some people are located in other countries, you need to make sure that you know who. It's always important to know who contributed to the different inventions, but it's also important to know where they were when they did it. Again, this is just something to keep in mind, keep track of. Tell your patent attorney, because your patent attorney is going to need to do certain things differently depending on where the invention was actually invented. It's called a foreign filing license.
And agreements. Agreements are incredibly important if you have offshore partners. Okay, so let's just throw everything back up on the screen here again. So, Chris and Ben, just looking at the overall sort of UX design here, where is the real IP value in your point of view? If you, let's say, we came to you, and if we don't get something on IP shortly, we're not going to get our next round of funding. Where would you suggest that we spend our money and sort of in what process, in what flow?
To attract investors and VCs, as I'm looking at this, getting your applications on with respect to your design is certainly a key aspect. Trade dress, just go through the rights. The trade dress rights, you're just new, you're just starting off. You're not going to be getting trade dress rights on that. I think it's helpful to get your trademarks on your names, just to sort of get those. You don't want to start building up your company, so you want to get your your trademark, and you can file that on an intent to use basis. Even if you haven't started using it yet, you can file it as an intent to use basis. It's like putting your marker down at the patent office, the trademark office. On the utility patents, just knowing what unless you really have it tied to some specific aspects of the mechanical aspects of this, to the devices, that's a large investment in order to make, but that might be an area to go with. The copyright, it's so cheap, you automatically have protection with your copyright, even if you don't. If I scribble down a poem right now, I technically have copyrights on that without actually registering it. But I would really key on that. And then prior to anything, you don't have to do this with if you're just trying to attract VC money, you don't have to go and do your clearance, but just know in the back of your mind, if you are the VC or you're going to do this, I'd want to know what is the patent landscape. I mean, yeah, they can have a lot of pending applications on file, but do they actually, are they actually going to be able to commercialize this product because the landscape is already taken up?
Okay, what's your thinking?
Well, I think I would definitely do, I would do the, what do you call that? The little alien with the ears.
Yes, it's a symbol.
That symbol. I would definitely get a trademark on that symbol. I get a static design patent and probably an animated design patent, because at the beginning Charles showed that it does a little twirly thing. I think I would probably go for a design patent on the headphones, but as I mentioned before, I'm not sure that I would include the entire headphone. I'd think about what is not going to change in the headphone. That's probably mostly what I would cover. I feel like right now the whole software patent thing is just such a waste of money. So.
You just open a question. Is a static design patent separate from an animated, or can you combine a static claim and an animated claim?
Okay, so it's what Chris said before, you get one claim per patent. So you can file them together. The patent office will make you separate.
They'll make you separate.
Yes. So sometimes you might file, imagine just the home screen on an iPhone where you have the slide one on.
Yeah.
You could have one design patent just on that screen as you see it, and then have a second design patent on the transition, showing it from the left position to the right position.
Now that
But
clarifies it, because it sounded like
Yeah,
a prior
two separate.
screen that you can do it in one to
Right.
show the whole process. So it turns out that I can't exactly show a process.
Well, it depends.
Yeah.
So in the prior screen, if you could show enough interim views that you could convince the examiner that it was a single design, then the examiner might let you keep it in one application. The problem is that would be such a narrow claim that I just don't think going forward that would really not have much value.
It's very interesting, actually, if you look at the U.S. Patent and Trademark Office currently, they're hiring examiners. So what is the category that they're hiring the most examiners in right now? GUI, by far. So, we're sitting in tonight, and on some level, this sounds very confusing, sort of unstable. The fact is that the system is evolving very rapidly. And I think that's one of the reasons that I felt very strong about doing this session, because there's really been very little context put around UX and IP and how all that sort of fits together. So, yes, go ahead.
So Beth and Chris, you both talked about how it's important to copyright the names, the logo, the way it looks. But what about the way it works and how, like user experience side of things, how it was designed, how it's supposed to act, and how it responds to the user? It's like, what part of that should you be, thinking about copywriting, or is it just not worth it because it's so hard to back it up with? Like the way when Apple did it, they must have spent so much money to win that lawsuit against Samsung for smaller startups and companies that don't have that kind of resources. Is it even worth it, or is it just pointless?
We should, being clear about what types of things is more of, when we're talking on the utility patent side, you're right, the design side, the aesthetic side, the utility patent side, the functional aspects of it. When you're talking about more like a process or a system and something very amorphous in general, that's where the law is being quite critical and saying, look, that's not even valid subject matter. But if you're talking about sort of specific things like, you're talking about pinch to zoom or something like that. Now, people might say, well, that's old as the hills or something like that, but let's just assume that that is novel, where you have 2 data points, not just panning with 1 finger, but where the computer says, okay, I'm moving 2 fingers at the same time. Am I going to get confused and think that you're trying to pan up and pan down at the same time? Or has there figured out something which says, no, when you're pinch to zoom, that means something different from that? Those are something that's more tangible, and if you've arrived at something like that, those are certainly things that I think can be patentable and should be looked into. Again, I think the advice, though, is to do a search up front before you take the big leap and just find out what the landscape is. I think some of that stuff is potentially, but again, that's something that's much more of a tangible idea than one of these sort of just ideas of taking money and moving it around and saying that that's patentable.
A good answer to that is when you go meet with your counsel the first time, and you take your UI, describe it to them in detail, how it actually behaves. That Chris, other leading IP attorneys, they have an idea immediately whether that's patentable. You might think it's innovative, like Chris said, or that said, there may be a huge field of prior art that's already covered, already patented, you're not even aware of it. So I think one of the most interesting things is to realize that the attorneys have two jobs when you go to visit them. One is to tell you what's patentable, and the second is to tell you where you might get into trouble by infringing other people's material. And that is probably as important as the visibility. The other thing that I've learned over doing this for a long time is that what you think is really innovative may not be innovative. So it's sort of the designer's bias when it comes to intellectual property. Another question? Yes.
Yeah, can you talk about the protection limitations in relations to international markets and strategies for, I guess the concern is when you file and when it's issued, is that public, is that accessible to people that are trying to, from other countries or, try to get the idea?
So each type of intellectual property is different, but with respect to patents, both design and utility patents, if you file in the United States, you do have a certain period of time in which you can file in other countries. And that's important because you want to get the filing date, you want to get the earliest filing date, you want to get credit for that. Now, moving from there to other countries in the United States, design patents are secret until they issue. In Europe, if you file a registration with the EU, you can ask them to defer it for a period of time in which you can keep it secret before they publish the registration. And something kind of like that exists in lots of other countries. But again, you have to keep in mind what your long-term strategy is and maybe when you plan on releasing your product and what countries you want to release it in and coordinate that.
And there is no worldwide patent. Okay, so it's every country, it's a jurisdictional base you need to apply for in each one of those particular countries. There are some type of formalities, treaties, which allow you to file once, like you said, within 6 months. You can be fined to file in those other countries. But we should also point out there are certain countries, like for instance China or India, where there is no grace period. Like we said, we have a 12-month grace period. You have to have your application on file before you ever have a public disclosure. So therefore, you want, again, yet another reason to have your filing on file before you have any type of public disclosure. I think one thing we did not mention was with respect to a provisional patent application. This is not your full-blown patent application. There's a cheaper way that you can put something on file at the patent office. If you know, gosh, I'm going to have a public showing at a trade show on Friday and I've never had a chance to I'm never going to get a patent on file before that, you can put a provisional patent application on file. But again, it's sort of, you only get a filing date for that which in your particular idea. So.
And provisionals only apply to utility patents.
Yeah.
I must answer that question for this week.
I think it's an observation, I guess, from what you were saying when you were going through the different, I would call it the ecosystem of that product portfolio. I guess what I found interesting was, and when I look at Apple, a lot of the things that I think that they do that are very cool is the interconnectivity of the ecosystem, meaning the watch talks to the phone, which talks to this. And I work with enterprise technology, and a lot of it, to me, the value, commercial value is about things connecting seamlessly to one another. I didn't quite hear that in the conversation, so just we're not there with the law, so therefore we're not talking about it, or I have to just separate very clearly the term IP in a legal formality versus IP as I also associate it to a commercial value.
I think it's the second thing you said. I think what you find is people bring us the ideas, we separate them out into the different buckets of what we can protect.
Yeah.
And then we say, if you have enough money, we recommend protecting in these certain number of buckets. And then, ironically, after you get your protection, when you decide you want to enforce it, you put all your things back together again.
Okay.
So for example, copyrights can be enforced at customs easily. Like you can keep things out of the United States if they're infringing a copyright. It might be easier to get a preliminary injunction using a design patent than it is to use a trademark, because you need a survey for trademarks, but you can get an expert for design patents. And I'm just giving you examples of how you can take all of the different IP rights and you can put them in your quiver, and then you can go off and you can have a lot more ways to get at the idea that they stole. Because they're not going to steal one thing. They're going to try to steal the interconnectivity, and at the moment we can't protect the interconnectivity, but the best we can do is to separate it into buckets, do what we can, and then bring it back together at the litigation or enforcement stage to try to say, listen, what they did was they stole our idea. Now, here's how you can make them pay for that. They infringed this copyright and this trademark and this utility patent, and that's, I mean, I think that's the genius of what Apple did, right? Was they didn't just come at the jury with a dry utility patent. They said they stole our idea. Now let us break it down and show you how that, they had a whole story. I mean, if you followed the case, they had a whole story, and then their IP happened to line up with their story, which I think was very helpful. I'm not sure that to a jury, I think a design patent is quite palatable. A trademark infringement case is quite palatable because it's just easier to understand in a lot of ways than a utility patent case. But at the same time, if they like your design patent case or they like your trademark case, they might be willing to listen to your utility patent case, you know, sort of with a little bit more of a bias towards you.
I would say also, I think there's trade dress protection. So if the interactivity or the interconnectedness of the various components of the system result in a unique user experience, and that becomes identified with your product, that then has trade dress protection. And what Chris was saying about trade dress, of course, is that trade dress has no limitation. I mean, for Apple, the trade dress win was the home run.
Yeah, I can see that.
And you're exactly right. That's the genius of their system for sure. That was just overturned on Monday. So, okay, yes, sir.
Yeah, so most of us, I think, here are doing web app and mobile app design. So we're working purely in software. And also, we're working much lower, higher level, I guess, than Apple with an actual OS. So if you're building on top of things like Bootstrap and frameworks of various types, you're building an app on iOS, and you've got to follow Apple's design guidelines. So when you're building on top of other guidelines or other frameworks, how much is that undermining your ability to protect something? Because I mean, you're using something that's definitely prior art and open source.
Yeah, I think one of the keys there, I think if you were to meet with an attorney in that process, they would try, let's try to separate the wheat from the chaff and try to make sure that any of those particular aspects are not being claimed that are theirs. In fact, in one of the examples we saw, there was all sorts of, there was a Twitter icon and a Facebook icon, those things we want to make sure we extract those type of things out. And you don't remember seeing was a mouse, a computer mouse in the shape of a Beetle bug, or the Volkswagen bug car. And the applicant was forced to say that the shape of that is the actual recognizing that's a trademark of somebody else's. So they were trying to divorce out that which was somebody else's. So I understand. I think that's a difficult situation. And frankly, I think some of the platforms are trying to do that, right? I mean, they're trying to make only use our tools, only use our particular visual elements. So that which you add, and then making sure. And one way to do it would be to disclaim those portions which would be proprietary to somewhere else.
Yeah, it's a great question. And the app development platforms, they want more and more standardization. The best example is the Apple Watch. Like you have almost no innovative replay in that system. The pixel definition of the buttons, position, the behaviors, all that. None of that is going to be protectable for the developers who are developing apps on that, because that is based on an industry standard production environment, and you cannot copyright that, you can't protect it. The only thing you protect are the innovations that you put into that. the branding, some aspects of the interface, the way it interfaces with your other apps. But anytime you have a standard-based system, but change, for example, a classic example of this was Windows. When you used to build Windows applications, they had their drag and drop GUI, right? So you build a whole GUI and you maybe had a couple of innovations. You couldn't protect any of that because you were using industry standard components. Apple and Android have taken that to a whole other level. So you have to be, that's where working with great counsel is extremely important. And one final thing I want to say, because it's about time to close up, it's very important to go to counsel who have experience in exactly the category of technologies you're dealing with. Don't go to a guy or a woman who is in hardware and has never done that. What you want to do, just take the time to make the calls, find someone who's got the experience in your specific field, and then go to them. They will have answers. Yes?
What would be the cost of patents in order to have all the rights for this particular product? So what would you patent?
Yeah. I mean, I think as far as conventional, just the conventional wisdom, I think it's a totally fair question. So, generally on trademarks, I think, if you look at there's economic surveys that have been done which survey all the IP counsel throughout the U.S. and then they compile this data. Let's say for a trademark application, budget $1,000, just generally speaking, for a trademark. Okay, we're going to talk each one of these different buckets. Design patents, somewhere between $2,000 and $3,000 is for the filing of a design patent application. And then probably for some of these utility patents we were talking about here were, and all of these things can vary obviously, but I'm just trying to answer your question as candidly as possible. Then when it comes to a utility patent, I mean, they're for a simple invention somewhere between $6,000 to $8,000, or more complicated, $8,000 to $12,000, for a very complicated type of platform, it can be all the way up to $20,000, $40,000. So there's sort of varying degrees of levels of protection, but that's something to work out with your IP professionals before you embark upon it. That's my thoughts. I don't know.
Yeah, no, I think those numbers are about right.
I just wanted to know, this is a kind of anecdotal question where I wanted to get your guys' thoughts on the landscape. You mentioned that something about you kind of wanted to deter other people from going out like this in the field. Do you feel in your experience that the landscape is, there's a lot of people who actively are trying to copy people, so to speak? Is there a lot of competition that way, or do you feel like some of it's accidental? How intense do you think, I guess, the question is with competitive copying?
Yeah, I don't think it's accidental. I think that it ranges from an absolute copy, sort of all the way to a highly inspired copy. I'm trying to look like you because I want to play off the feelings and relationships you have with your customers, all the way to I'm just completely copying you. What I think my experience with design patents is that they're not typically litigated as much as utility patents. And some people get the impression that means that people aren't using them, and I don't think that's the case. I think there's more of the real easy cases where someone's copying. Maybe that person didn't know there was a patent, and when they find out about it, maybe they're willing to make a change. My hope in the UX area is that because it's a little bit easier to make the change, you have a tool to factory, right? So hopefully that means that if the person's really a good actor and they're trying to, oh, I got a little too close, okay, I'll negotiate this, I'll back off. I mean, I feel like that's hopefully where we are. I feel like Apple Samsung, it set an unrealistic precedent because it was such huge titans who were spending so much money, and I just don't think that's how most people are going to use these patents. I think most people are going to mark their product, they're going to put patent pending on it after they file the patents, then eventually they're going to come up with some way of marking their product. You can either put the numbers on it or you can do what we call virtual marking. Again, an attorney can tell you about it, but the point is that you want to communicate to people that you have this protection so that they will hopefully go look it up and then make a different choice.
Okay, I think one final question, then we have to close because we have to be out on time. So, one more question. And Chris and Beth are going to stay, so. All right, one more question. You in the back? Red shirt?
Yeah, well, I just want to piggyback on her own question she asked. Like, do you see like drawing companies or just like going and looking at people's design and copying them? I mean, how I go to a lot of hackathons, I go to a lot of places in which people are just like, we're just putting their ideas out there. Like, how or where should we be? Like, is it real, like a real problem? I mean, and we're just not aware of it, just become profitable. We get like an app that is a hit, control, or just,
Yeah.
I mean, I just like, I've never even heard of this as a problem.
No. Yeah, I think as far as the trolls, I mean, you have much more problem with people copying designs than with trolls. I mean, these are relatively narrow rights, what you're talking about. For someone to land on your exact design, you know, I've been doing this almost 20 years, and it just doesn't happen. You know, it just doesn't happen. Somebody has even seen it. Maybe they've crossed the line, okay, but two people don't arrive at the same thing when it comes to one of these designs with how many elements are at play in a design arrive at the same time. I do know, I would say this, that sometimes clients will come and ask and say, I don't want to step on someone's toe, but we want to make a product that's in the same category. I want to give me a clearance opinion. So we'll go up, we'll call up the relative, maybe the utility patents, we'll do a search, find out the design patents. And I will say that the most difficult one that I've had was where it was somebody that we know well, was very much a protagonist in this area of patent design, IP, and UX design. And that the thicket that he had created with this particular portfolio was almost impenetrable. I mean, it was extremely difficult to try to get at because there was so many different, things, not just patenting one design patent on thing, but so many different particular angles, elements that were being protected individually so that the building blocks were sort of scooped up. And so it took a lot to try to, and it took not only analyze it, but try to find out where the safe harbors were. So in that sense, it could be used as a sword to make any people trying to come in a barrier to entry into a particular market. But the type of thing of just trolling for it, if you can get it, it's so easy. It wouldn't be worth a while to enforce it. It's quite easy to design around it if there's only one design patent at play.
Okay, thank you.